our side as we wind down today's activities. As I mentioned, it's been long, but it's been a necessary exercise of going through some objections and then hearing the responses and having the court make a determination of what it would allow and what it would not allow in the witness statement. Let me start by recapping where we are in this trial and why we are here. The petitioner, Mr. John Dramani Mahama, former President of the Republic, invoked the jurisdiction of the Supreme Court, among other things, to say that based on the data contained in the declaration of the first respondent and the second respondent being declared as President-elect of the Republic of Ghana, no candidate will obtain more than 50% of the valid votes cast as required by Article 63(3). The petition also essentially makes the argument that the threshold of Article 63(3) was not met and that the declaration was in violation of Article 63(3). Goes on further to say that there were errors and mistakes and other things which will materially affect this election, and outlined 5 witnesses who would help adduce evidence to prove same. We all witnessed Mr. Johnson Asiedun Ketia come into the witness box and give testimony, and I think the jury is out on whether or not he was able to establish any of these things. And then we had Dr. Kpesa White take the witness box and mostly lead evidence to the effect that they considered that they were deceived by the EC chair to leave the strong room when the national or the presidential final results were being collated. Indeed, the word he used was that he was instructed, and subsequently he admitted that he cannot be instructed by the EC chair. Now, today, the petitioner introduced a third witness, Mr. Rojo Nunu, who was one of those 2 in the strong room, who is the one that we were all expecting would take the witness box initially. And there were a number of paragraphs that he had outlined that he wanted to adduce before the court, some of which we objected to. In the end, the court upheld what we believe are some of the most substantial ones, paragraphs 4, 5, 6, 7, and 18. The court upheld those ones and struck it out. On Monday, we are coming in for cross-examination. Like they say, it's one thing putting something before the court, it's another thing defending it when it comes to cross-examination. And so counsel on our side, and we believe counsel on the side of the first respondent, look forward to an opportunity on Monday to now put the paragraphs that have been admitted in Rojo's witness statement to the test under cross-examination. Essentially, that is what has happened today, as I'm sure you are aware. We are happy that finally Rojo will be in the witness box so that some very important questions can be put to him and the bench or the court can take judicial notice of whether or not those answers to those questions and those arguments that are being proffered go in any way to help deal with the issues before the court. And as I wrap up, let me take you through the issues. Sometimes when you follow the long conversations, you forget what the court is trying to answer. The court is answering 1 question of law, 3 questions of fact, and 1 question of law that arises as a result of a fact. The question of law is whether or not the petitioner in his petition has any reasonable cause of action. The questions of fact are whether or not, based on the data, nobody got 50%. Whether or not the Article 63(3) threshold was met is a question of law, as I've mentioned earlier. But whether or not you include or exclude Techim and South, does it change? And then the other question of fact is whether or not all the so-called errors and vote padding affect the outcome of the presidential election results. The last question of law, which comes from fact, is whether or not the declaration will therefore be in violation of Article 63(3). If you find that at all material times Nana Akufo-Addo exceeded the 50% threshold, then that question of law will be answered in his favor, that then it was not unconstitutional. So we believe that we are making progress gradually. We are at a point where the third witness will be put in the box, and we'll see whether his argument stands up. What is interesting to note is that When our colleagues don't get a win in the wells of the Supreme Court, when they come, they say the decisions don't make sense, that the court is not being fair to them, etc. But today, you notice that as they got some of their arguments upheld, they seem to think that the court is the best so far. But we'll live to see what is out ahead of us. They describe it as a great victory. And let me explain to you why they describe it as a great victory. They describe it as a great victory because they realize that Dr. Kpetsahwai's testimony fell flat, could not stand the test of time. And therefore, they've tried to bring in Rojo, who initially they came with some reasons not to bring, so that he can, and if you listen to the arguments of counsel for plaintiff, Mr. Chachuchi Kata, he makes the argument that during cross-examination, some very significant damage was made to the argument. And therefore, it is proper for them to bring in Rojo to try and re-establish some of those ones. So for them, if many of them had been struck out, it would be a very devastating day because then it goes to buttress the point that where Rojo failed, where Kpetsahwai failed, nobody can attempt to save him. Now, they seek to bring in Rojo to try and save Kpetsahwai where he fell flat. And we are pleased that at least they are no longer trying to poison the minds of the public against the court. We look forward to what Monday will bring. We'll take your questions.
All right, so the first question I ask is that today in court, after lawyer for the petitioner finished his submission, we saw the lawyer for the electoral commission, the first respondent, making an argument that it appears the court seems to be going a certain direction in a petition where they are allowing the petitioners to speak before the respondent, when it's supposed to be the petitioners first before the respondent. Is this something that you identify with as second respondent? Because I didn't hear your lawyer talk about
That's true.
That's
true. Well, let me quickly respond to that. What the counsel for the first respondent said was to draw the attention of the court to the fact that the procedure as it's unfolding, it appears to be deviating from the norm. The norm is that the petitioner makes his case first, and then the respondent responds. And even by CI 99, you are not allowed the opportunity of a reply. If you look at witness statements, for example, the petitioner refused the orders of the court to file the witness statement. What it meant was that the one responding rather put in his witness statement, as did the first respondent, and the petitioner then had opportunity to read it and attempt to now put in witness statements. So it's like the respondent is now going ahead and the petitioner is looking to how to close their gaps behind. In the case of calling witnesses, properly so called, you will notice that at the deadline for filing witness statements, Rojo Metunu's statement was never filed. They came to see the justices in chambers and made an application, which we didn't object to, because we believe there are some questions he must answer. But what has happened is that after Kpetsahwai has been cross-examined and his case has fallen flat, then they bring in Rojo seeking to correct or salvage some parts of that case. It is that which the counsel for the first respondent is drawing the attention to the court, that that is not the normal practice, and that they are literally allowing the petitioner to turn the rules upside down. I think it's obvious that the court is being very magnanimous. In fact, he used the word magnanimity. The court is being very magnanimous in hearing all sides and allowing things that ordinarily it will not allow. But, like we keep saying, always go back to the issues. What are the issues that the court is seeking to answer? And we are of the view that whatever things about fax machines not working, about phone call that they couldn't hear from, and then about deceit and a few other things, whether or not it changes 4751.2 or it changes the constitutionality of Article 63.3 is something that the bench will determine eventually. You have to speak up, sir, so that we can hear you. No, I haven't said that.
Justice delayed, justice denied.
Well, in the end, the court seeks to do justice, and seeks to do it in accordance with law. Justice must be done, but justice must be done in accordance with law. You cannot do justice outside the law. That would be extrajudicial attempt to establish justice. We've had a history in our country where some people have elected that they don't want to do things in accordance with the law. They have executed people without due process. They have confiscated properties without due process. We have now come into a democratic era. So everything, including justice, the rule of law, is hinged on the Constitution and is hinged on law. So justice is what we expect to be done in this manner, or in this matter, and we expect that it will be done in accordance with law. That is why whatever prayers we have, we'll say it before the court, they will rise, think through it, and then they will come back. What we must not do is to bastardize the courts when we don't get our way. And that's why I made the point that you notice that our friends, when they don't get their prayers upheld, they come here and they say, it doesn't make sense. They are not being fair. Today, when some of the arguments are upheld, they literally say that the court is the best court that they have seen. We must be consistent. We've been consistent from day one, that we are in the hands of the court. Yes, sir. Well, where are we in this process? We are at a point where the petitioner is still trying to establish his case. The petitioner has not established his case, or has not told the court that they have closed their case, that they believe they have substantively made a case before the court. What they've done is to make some pleadings and call 2 witnesses so far, Johnson Esiedun Ketia, the General Secretary and the coordinator of the entire electoral program, who came in, calculator in hand, he ended up with 4751. 4751, plus or minus Techima and South, 4751. You never saw him calculate and say, nobody got 50%. Then they moved on to Pesa White, and you were wondering whether he will also come and perhaps be the one to provide the evidence that will show that nobody won. Because remember, they have told the millions of their supporters across this country that they won. Many of them believed them, got on the streets. They came to court, now they say they didn't win, but nobody won. So at least you were expecting that one of their witnesses will prove that nobody won, even if you forgive them for the first exercise of deceit of the Ghanaian public and their supporters. Pesa White gets into the box, and the gravamen of his testimony is that they were deceived by the EC chair. He uses the word instruct to leave. And at the end of his testimony, one question from Counsel Akoto Ampao, I put it to you that you cannot be instructed to leave. He admits, and the whole testimony crumbles. So now you find that they go and bring our very good friend Rojo Metununu, who we were all hoping they would put in the witness box in the very first case, because he was the one granting the TV interviews and claiming in those interviews some things, which I won't say now because cross-examination hasn't started. They are now at a point where they are trying to make their case. It is when they succeed in making a case and tell the court that, my lord, we have closed our case, that a certain threshold may or may not have been met, in which instance we and the first respondents may have an obligation to also open or advance a case. So it's early days yet. Bear in mind that they have made some specific allegations out there. They have to prove it in the court of law. Until then, we don't even have a case so much to make. We are ready. Chairman McMahon comes every day with his pink sheets and his regional coalition sheets and his Form 12s, and is ready that if it becomes necessary that he mounts the witness box and prove that Nana Akufo-Addo indeed got 51.2 and beyond, he's happy to do it. But they have to prove their case first, because he who alleges must prove. Check section 14, section 17 of the Evidence Act. So Rojo will have to now come into the box, make his allegations, prove same, and be cross-examined on it before we move to the next steps.
Now, you are saying that you are happy with the ruling. How do you link these two to saying that you are happy that ruling is
First of all, let me show you what is interesting. There are supposedly 2 people who have been sent to go and protect the interest of Mr. John Dramani Mahama at the EC Strong Room. Person 1 is the principal party. Person 2 is more or less the supporting actor. person 1 goes to give or goes to have a conversation and supposedly reports to person 2 that both of them should leave. And at the material time when the petitioner wants to adduce this evidence, he opts to bring person 2 and says person 1 should come and corroborate. Anybody who is following it begins to realize that something funny is going on here. Because ideally, you will bring in Rojo and then rather look to get somebody to corroborate, assuming his evidence is not enough. They flipped it the other way around, no wahala. But we are happy to have Rojo in the box because there are some questions that will be put to him. That is why on the other day, we were saying that perhaps they didn't bring him because they were of the view that if he comes, he will perjure himself. Now he has come, he has tendered in his witness statement. The technicalities of what must be accepted and what doesn't meet the standard have been dispatched with. Now the questions are going to be put to him to see whether his argument, what they tell the NDC supporters, what he told the supporters, whether it can stand the test of scrutiny in court. And that's why we're very pleased at where we are. Remember, a case is now being made, and we are now at the point where we are cross-examining that case. When it is done, if we have to now get into a full response, then we'll get into it. I want to say thank you and invite my colleague Fatih to sum up in chief for us.
Honorable Kojo Ponkroma, Minister Designate, Eddie Abreno, Ehubehia say, Mebono Tofa Akankasem. Na Nientia ye PMU a Haneno, Mijidi Sewa Woody in Semni in the Chino Obekaya, a former President John Dramani Mahama, and was Sama, a electoral commission. And President Kufuado Ewo Asenibiaha say abaye koto on 7 December nebobo any declaration eba ne bonyo so na sese no ne asem na kodu ni de beba na emom ye pese e kan mo say ensem na court no be kan nyina omu bebua niema num na ne edi kan ene say asem a omatwagu petition no so de aba bedan court no say wo nyina so ana say ni nyina so ne etoso mienu NSS court ayabai abaye to on 7 December no presidential candidate no obi anya ohamu abupen aduonum ni achi ebio nso so court no ebebua say eye declaration EC ba panyima me Jean Mensa o declare no say ebuga na mrapon na say embu mrapon no na bio obesa bua say eye aba oto Techiman South abato mpesu aso no senka or the results no ebobo etwen bobo kan ho anka be yen sakyraye bi e wo abato no outcome no ma na ne etwa to okra ene say allegation bi a petitioner ne de aba say mani bi wo ha nkontabuo mu ne ye de kan obi de ho se sa ama no ye bua ne nyina se betime de ensakyraye bi aba abato no nsunsu anso so ana na sansemu num yi na enema ye kan o court ha nyina le wi a court no bebua na samu be kan a na no ukuada a court no sorry asem no so no na ye hwe anim si ebehia na enra eye petitioner no ebo court no kokose nyame adoma anapai o mbesa de odansini fofora beka ho se obekan a ebra petitioner no file petition no obo court no kokose nka obefre adansifo num enso so asat ukuada na ye free ha say na adansifo na mu mienu pe e na pe witness statement e ba ne cross examination ayaye no maba enti sa kokoboy ehu asem nanka na pai ye ba betie sa dansini otoso miensa eye owura Robert Joseph Metal nunu na no asem na afei nso so eye electoral commission ne president na Akufo-Addo ma lawyer for enso so enya akwanya atoto na no na enso so ye bepie mu aha na pai obakan a eye adanse a owura Robert Joseph Metal nunu ochrogu krata so ema lawyer for de bepie mu aha no na President Akufo-Addo ne lawyers a lawyer penyi odi anim eye owura Akoto Ampaw o se ensem ni bi wo ha otiem na edi enti na nsem na no mode abedan court no so otiem na otiem free say wo hwe emra na ede adwuma wa ha say na odansini na yayi no enyo no ode na asem abedan court enti nkebe ya ensem a wode ba aba na adanse a ode ba court na nim no esese ye ensem a wo fapem wo petition na mode abedan court no na eni kwan say ye ensem a ne petition no mu ensem a na pleadings no ebo ebra na ebio ensem ni bi won so a eye omampanyi lawyer owura Akoto Ampaw o ne mpanyimfo akuku da meka no ho ehun say eye ensem anka ene asem a ye kan emfa kwan bia so nanso so omo pe kwati kwan bi e de aba be hyem na afei nso so sɛ yɛka witness statement na ɛsɛ sɛ nka yɛ nsɛm a ɛyɛ wonim deɛ na bibi a wonim ho bia na wodi ho adanse ɛnya adwenkyerɛ na nsɛm na ɔmatwerɛ gu witness statement no emumu bi nso so yɛ adwenkyerɛ a ɛne mmara no nso so bɔ ɛbra enti anapa owura koto ampa etia nsɛm no bi mu ɛma court no nso so ma ɛyɛ petitioner no lawyer akwanya mo no nso so ɛka bi na ne court no ɛka kosi ya ne sɛ ensɛm na ɛwɔ witness statement no mu emu paragraph 4 5 6 7 any paragraph 18 deɛ court na twam sɛ eni nyina so eni nsunsuaso bi a wasɛm a yɛbɛka mu na ɛno no krampo nkyerɛ sɛ witness statement na aka no yɛgye mene daabi ɛnam sɛ afei na abɛda court n'anim na ɛyɛ ade ɔmagye sɛ ɔmo bɛyɛ ɛbɛhwɛ ame ade ayɛ adwuma nti afei na nyame adom a ɛdwoada sɛ a lawyer for first and second respondent enya akwanya ombegyina saa nsɛm na owura Rojo metal nunu ɛde abɛda court no ahwɛ so na ɔmode atoto na no enti ne ene court so court na mabɔ no tofa akyerɛ mu no timi damase na general wa ha na kakra me pese me de ka ho ne sɛ mo bɛkan a utimi ho sɛ adansefo a petitioner ne di kan frɛ mo bɛgyina adaka mu ɛyɛ owura Johnson ɛsi edu nketia a ɔno na general secretary for NDC na aba yɛ kɔto yɛ no party na aba ne ho ne nkan ne bibia ɔno na edi mu tintiman ɛne owura ɛyɛ Dr. Michael Pesa White adanse ɔmo de ba nyinaa the way na adanse no mu ɔha ne nti utimi sɛ no na abɔ ɔmo ho a ɛho abɛhia sɛ ɔmo nipa baako a na aka strong room hɔ no atɔ kɔ sɛ ɔmo kɔtwe ne bɛgyina adaka mu nanso so sɛ wohwɛ witness statement ya aba ene ya ene dada aba no ensonso ya bi anhye da ni musa ɛyɛ asomasoma ne yɛ soma me ya no musa de bɛdan court na abɛkan a ɛbra na ɛyɛ president lawyer panyi owura koto ampaw ɛyɛ owura Pesa White cross examination ɔka kyerɛ ne sɛ unyo obi a EC chairperson no wotumi sɛ ɔsoma wana sɛ ɔhyɛw ɛma sorry free saa coalition center hɔ no mokɔ na saa asɛm wo yɛ de pem no bo no wantima anyi ho akyinyi ɔgye tu mu sɛ EC chairperson ɛni tumi bi a ɔde bɛsoma no enti yɛhwɛ anim sɛ nyame adom a adwoada ɛwɔ yɛ anim sɛ ne dada no yɛ no saa na wo nso bɛyɛ because yɛhu witness statement no ɛte saa wana enti nyame adom a yɛgye di sɛ a lawyer for akuku dam ɔmudi anim no ɔmbɛtete mu medam ase